Okay, well, welcome everyone to our first event of the semester. My name is Chloe Knox, and I'm the Vice President for Speakers for UVA's Federalist Society chapter. The Federalist Society for Law and Public Policy Studies is a group of conservatives and libertarians interested in the current state of the legal order. It is founded on the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Today, we're honored to be joined by Professor Scott Ballenger and Mr. Noel Francisco. Professor Ballenger is the director of UVA Law's Appellate Litigation Clinic. After receiving his JD from UVA, he clerked on the Ninth Circuit, as well as the Supreme Court for Justice Scalia. He then served in the Antitrust Division at the Department of Justice before joining Latham & Watkins' DC office, where he spent 20 years in the firm's Supreme Court in appellate practice. Professor Ballenger has argued numerous times in the federal courts of appeals, as well as the Supreme Court. Mr. Francisco is a graduate of Chicago Law School. He clerked on the Fourth Circuit, as well as the Supreme Court for Justice Scalia during the same term as Professor Ballenger. After briefly working in private practice, Mr. Francisco served in the George W. Bush administration, first in White House counsel and then at DOJ in the Office of Legal Counsel. In 2005, he joined Jones Day's DC office, eventually becoming chair of the firm's government regulation practice. In 2017, he was confirmed by the Senate to serve as the 48th Solicitor General of the United States. He returned to Jones Day last year, where he is now partner in charge of its DC office. Thank you both so much for joining us today. We really appreciate it. Before I hand it over to Professor Ballenger, I just want the audience members to know that you can submit questions throughout the event via the Q&A feature at the bottom of your screen, and Professor Ballenger is going to read those aloud during the Q&A portion at the end. And with that, I'm going to go ahead and turn it over to Professor Ballenger.
So thanks for joining us, everyone. I'll try and watch the Q&A feature, but we'll probably just try and talk for half an hour or 40 minutes or so before I start looking too hard at what the questions are. So Noel, thank you so much for joining us. We really appreciate it. This is awesome.
Glad to be here, Scott.
So tell everybody where you are, because you have a better tan than you have any right to have. And
yeah. So I've been mostly working remotely from a house at the beach in North Carolina. The downside is I end up sitting in a small bedroom like this all day long doing work. The upside is it's warm enough that I can get outside and do things on the weekends and when time allows.
So I have found with my little clinic that the one positive thing to come out of this whole COVID mess is that everybody's sitting in front of a computer. So it's a lot easier to get great guest speakers and talk to people you don't ordinarily have a chance to talk to. And here we are.
Well, on the other hand, I could tell you, I would be perfectly delighted to drive down and spend the afternoon in Charlottesville with you and do this in person if we could. So that might be helpful at other places. Charlottesville, I think you're a pretty good draw either way.
That's probably right. Well, thank you again. I really appreciate it. So as Chloe said, we met each other 25 years ago or something when showing up at Justice Scalia's chambers for OT 97. What are your best memories of that time together and of Justice Scalia? I mean, I have my own stories, but I'd love to hear yours.
So we probably have a lot of the same stories from that time together. Let me give you one about the justice and then one about our co-clerks. My favorite story about Justice Scalia that you probably remember is one where he had written a dissenting opinion and he gave it to us to look at. And it was a classic Justice Scalia dissenting opinion with all of the great zingers and one-liners. And you and I and Rachel and AJ all read it. And we went to him and said, Justice, we think this is a wonderful opinion. But there are a couple of other justices who are also dissenting. And we think that if you tone down a little bit of the rhetoric, you might get them to join this opinion because I think they'll agree with it. And he said, oh, that's a good idea. Let me think about that. And he takes the opinion back and he goes back into his chambers for another hour or two. And then he comes back out and gives us a redraft. And we look at it and much to our surprise, he has actually jacked up the rhetoric. And so again, we said, Justice, we think this is great, but we think you might get a couple of people to sign if you tone it down a little. And he sort of looked down at the opinion, and he looked up at us, and he looked down at the opinion, and back up at us. And I'll never forget it. He said, sometimes I just got to be me. And, you know, over the years, I've thought back on that story and what he was getting at. And what I've come to at least believe is that what he was saying to us is, I'm not writing for my colleagues when I write a dissent like this. I lost this particular case, and it doesn't really matter whether I lost this particular case by myself or I lost this particular case with a couple of colleagues joining my opinion, because I've lost this particular case. So he's no longer engaging in the debate with his colleagues. Rather, what he's doing at that point is he's engaging in the debate across time. And his goal is no longer to convince his colleagues that it's right. It's to convince other people, including future generations of lawyers, including law students like those that are with us today, that he was right. So that in the debate across time about how you should be approaching the job of being a Supreme Court justice, he's going to convince people to agree with his point of view. And frankly, if you look at the results today, I think he was pretty darn successful. Back then, Justice Scalia was one of the very few strict textualists on the court. Now you've got probably a majority of 5 that adhere to the textualist view that he espoused then alone. And amongst that group, you can probably include some of the more liberal justices on the court. So that's my favorite story about Justice Scalia, and one that it really, to me, epitomizes what he was about. My favorite story about our law clerks was back then, unlike today, back then the death penalty was much more widely used amongst the states. And in fact, our year, Texas hit its high water mark for executions, and California was in fact engaging in a fair number of executions as well. And one evening, there was an execution out of California set for midnight West Coast time, 3 o'clock in the morning our time. And what that meant is that the law clerks had to be on hand to handle any last minute petitions that were filed. So around 2 in the morning, I was wandering down the hallway, checking in with the other clerks that were tasked with staying late that night. And I walked into the office of one of our colleagues, and sitting on his desk was this massive white chocolate sculpture of the Capitol. And I said to him, "What's that? Where'd you get that?" And he said, "Oh yeah, look, Justice O'Connor gave this to me. I guess somebody sent it in and she didn't want it." So the two of us sat there and devoured, the House side of the Capitol. And then I wandered back to my office. Our work wound up for the evening. We went home. I rolled in the next morning a little bit late, around 9:30 or 10, since we'd been there so late. And amongst the police officers, there was a huge buzz going around about how somebody had stolen Justice O'Connor's white chocolate sculpture of the Capitol. And as I pieced it together, I think that what might have happened is that, Scott, you may remember that Justice Scalia received a lot of random gifts from people. And there was always a table that he'd set the random gifts on. And we were allowed to go and take them from that table because it meant he didn't want them. I think Justice O'Connor had a similar practice, but this particular thing she actually wanted because she was going to use it for a party. And our colleague misunderstood and thought that it was out there for the taking and had in fact taken it. So that just kind of gives you, it's an interesting job, it's a serious job, but there's a lot of goofiness that sometimes goes on late in the halls amongst a very young group of lawyers who are working very hard.
Did you ever get busted by Justice O'Connor for having eaten her cake?
No, I don't think anybody really blamed me. And the reason I feel like I can talk about this is because one of our colleagues, I can't remember which one, actually wrote about this in a law review article. One of our other fellow law clerks that year.
So my favorite memories of Justice Scalia are the time that I asked him to explain when to use which and that. And his face just lit up. Like nothing made him happier than an opportunity to teach me a little bit of grammar. And he pulled a giant dictionary off the shelf and sat down. Scott, let me tell you how this works. Nothing made him happier than teaching.
That's true.
So there's this, long-standing story out in the world that every year Justice Scalia hires a sort of counter clerk, somebody to take the opposite side of what he's likely to think about cases. And I guess I wanted to ask you, what was it like being that person?
Yeah, I was very happy to fulfill that role. No, I get asked that question a lot, and there's some truth to it, but I don't think people fully understand what it means. Justice Scalia was very open to hiring somebody who had a very different view of the world and of the law than he did. It wasn't like he automatically did it every year, as you know, but he was very much open to doing that. But I think people misunderstand what the role of that law clerk is. That law clerk's role was not to try to convince Scalia that originalism was the wrong approach or that textualism was the wrong approach, because that would just make for a very frustrating year for both of them. You don't become a Supreme Court justice without having well thought out views, and nobody is going to change your basic approach to the law. The role of the so-called counter clerk, and what a good counter clerk would do, is make sure that Justice Scalia was being true to the principles that he espoused. Look, everyone is at risk of, trying to apply neutral principles, letting their own personal views bleed into the application of the neutral principles and shade their views away from where the neutral principles might naturally lead to. And the counter clerk was there to make sure that Justice Scalia wasn't doing that. So that if originalism or textualism led to a result that he might not himself personally like, so be it. You're essentially supposed to hold his feet to the fire. And that's what I think an effective so-called counter clerk would do when they were there. The ineffective ones were just frustrating, and you'd just be arguing over things that you were never going to convince him about.
I don't remember us doing a whole lot of that.
No.
Do you remember him changing his mind?
Not on anything big. I can remember some small cases going in early on and him having a particular view and coming around to a different view, but he didn't ever change his mind on the major issues of the day that I recall.
So one thing that people ask me a lot is, what was the chamber's process for sort of talking through what the right, outcome for cases was? Can you talk a little bit about what we did?
Sure. I think I can tell you what the process was, but to a certain extent, I'm not sure that was really how Justice Scalia always made his decisions. Before the justice actually cast a vote on a particular case, he would call all the law clerks in and have us debate the issue in front of him. Sometimes I just think that was because he found it entertaining, not because it actually impacted his vote. But we would go into his chambers, the five of us, and essentially have a free-for-all on the case to help him figure out how he wanted to vote. And after that, he would go and cast his vote. I can't actually recall it ever impacting his views, but maybe you have a different memory of that than I do, Scott.
No, I'm not sure I ever saw him change where he was, at the beginning of that exercise, at the end of that exercise. I did think, a few times that his initial reaction to a case when we first started talking about it, was not at all where he ended up.
That is for sure.
He was a very careful lawyer, and he cared about
that is for sure. But you'd often have conversations with him very early on. You pound around a few ideas. What I found is he didn't usually lock himself in that early on. And so he wasn't really changing his mind. He was just sort of asking questions to get a feel for it. Once he kind of dug into it and came to a considered view, I don't know that I saw him change it all that often on something like that.
So a corollary to all of that is that I found the clerkship just an absolute delight, and not, particularly difficult job as jobs went, because almost all of the time you could figure out pretty well where Justice Scalia was going to be and what the right answer was, right? Part of his philosophy of, not leaving the lower courts in the dark, but trying to anticipate not just the right answer to this case but the next 3 or 4 cases. Part of the consequence of that was to make life pretty easy on law clerks.
Yeah, I think that's right. And also because he was so smart and read everything himself and could digest it so quickly, whereas some of our colleagues and some of the other justices wanted very long briefing memos, going through all of the briefs and all of the arguments. Justice Scalia limited us to 2 pages. So he would want a bench memo before a case, but the bench memo was limited to 2 pages. And I remember very early on, Scott, our first summer there, when I think he was traveling in Ireland, and one of these emergency motions came up, and it was assigned to our chambers, and we were supposed to draft up a memorandum to be circulated to the other justices from him. I remember doing the first draft, and I called him in Ireland, and the first thing he asked me was, "How long is it?" I said, "It's 3 pages." He said, "Get it down to 2 and call me back." Click.
Awesome.
So it focuses your thinking.
I still think that was the most useful writing practice and exercise I ever had.
Yeah.
So
not only the most useful writing practice, but one thing, and this may be good for some of the law students and younger lawyers out there, is one thing you need to learn to do as you move up through the chain is how to explain your views both to the more senior folks, partners that you're working with, to your clients, and to the courts, how to explain your views very efficiently. Early on, when I was working in the White House counsel's office, then at the Department of Justice, I learned that when you're speaking to a very busy decision maker, you've got no more than 2 minutes to catch their attention. And if in 2 minutes you have not explained your essential point in a way that either gives them what they need to decide or makes them sufficiently interested that they want to hear more, you're not going to get anywhere. And that 2-page bench memo was a good exercise in how to focus your thinking in order to get your point down to 2 minutes.
Everything about the academic world sends students the opposite message, right? I supervise independent studies now, and the policy is if it's 30,000 words, you get 3 credits, and if it's only 20,000 words, you get 2 credits. And yeah. I want to tell people, no, like make it 5,000, and then we'll really have something. Oh well.
Yeah.
So you mentioned your time in the Bush administration after we left Justice Scalia. You did 2 stints, or was it one long stint?
It was one long stint with 2 jobs. Started out in the White House counsel's office, then went over to the Department of Justice. Not uncommon.
So tell us about your time in the White House counsel's office. What was that like? What did you work on?
Oh, it was fascinating. When you're in the White House counsel's office, very rarely do you get deep into any particular issue. You don't have time. So if it requires hard and deep thinking, you farm it out to the Department of Justice. What's exciting about working in the White House counsel's office is that you're in the middle of all the action. And people probably, your students probably won't remember all these names, but back then, President Bush's White House counsel was a guy named Alberto Gonzales, and his chief political strategist was a man named Karl Rove. And Judge Gonzales and Karl Rove had offices right next to one another in the West Wing. The best place to hang out in the West Wing was right outside of those doors, because Karl Rove would have just a line of celebrities walking in and out of his office to talk about various issues. So that's where I met Bono. That's where I met Bruce Willis. I can recall one afternoon sitting in the what's called the White House mess, which is the lunchroom where the staff eat and where they can bring guests to eat. And the Deputy Chief of Staff, Josh Bolton, walked in with Bo Derek, who rumor was at least he was dating at the time. So the great thing about working in the White House is more the excitement factor. You're in the middle of everything. You're seeing famous people. You're in the middle of big decisions. There's a lot of pinch me moments. It wasn't necessarily the most interesting legal job. though, just in terms of the types of legal issues you're digging into. When I went over to the Department of Justice in the Office of Legal Counsel, it was the opposite of that, because OLC is essentially the internal court, so to speak, for the executive branch. It resolves disputes between the agencies when they disagree on a legal question. It provides definitive advice to the president on all of his executive orders and the legality of a lot of the policies he wants to pursue. So in a sense, it's a pure law shop. And you're very much sitting in an office studying issues and writing legal opinions, providing advice to other executive branch agents.
I remember Justice Scalia telling us that OLC was the best lawyer's job in the government. Is he right?
Second best.
Well, he never got.
I think the Solicitor General's office is the best lawyer's job in government. I think OLC is number 2 to that.
So what did you work on while you were there?
At OLC? You know, it's a whole range of issues, ranging from the mundane to the interesting. I think the most interesting thing I worked on was there was actually a law professor who was on one of the president's advisory commissions, and who was also up for an appointment at the Vatican. And the question was, did that violate the Foreign Emoluments Clause, which prevents, and I can't remember the exact language, but it prevents an officer of the United States from holding an office or title of a foreign government. And so there are a lot of questions. There was one, do you consider the Vatican a foreign government? 2, do you consider whatever position this professor was looking at the Vatican, would you consider that an office under the Vatican? 3, would you consider an advisory committee, a member of an advisory committee to the president to be an office of the United States? So it was a really interesting set of issues that hadn't gotten in all these years any significant treatment from OLC or from anyone else. So in order to resolve it, there were no executive branch opinions on point. There were very few federal court opinions on point. We ended up diving into all of the old state law cases about state constitutional provisions that were similar, to see how state courts had interpreted it. And when you really dove into the history and looked at all the old state law decisions, what the theme that emerged was that nobody thought that an officer covered by this clause was somebody who had a purely advisory function. All of the officers were somebody who actually had some kind of authority to exercise the sovereign power of the government. But if the only power you have is to say, hey, here's what I think, you ought to do this, you ought to do that, you don't qualify as an officer within the meaning of that clause.
So you could be on a scientific advisory board for the British government about whether they should approve the Pfizer vaccine or something. But
exactly, as long as you don't have any authority to actually approve it yourself, but all you're doing is saying, I think you should approve it, then you don't qualify.
It also seems pretty unfair that pretty much anybody can be a deacon or lay leader in any other religious institution, but since the Catholic Church happens to also be state.
That's interesting. I actually didn't even think of it that way, but I guess it wouldn't necessarily arise if you were a priest in a local parish, as opposed to somebody who's being appointed by an official Vatican entity, because the Vatican, I think, is different than a St. Anne's Parish in Washington, D.C. So
that's probably right. So after that stint at OLC, you went to Jones Day in DC. What attracted you to Jones Day, and what was your practice like?
Yeah, so I think the main thing that attracted me to Jones Day at the time was that I had some very close friends who were practicing there that said good things about it, and I wanted to go somewhere where I knew people and was comfortable. But what kept me at Jones Day was just the collegial working environment and the extraordinarily interesting opportunities that the firm gave me. And so it was during my time there that I was able to develop a legal practice that primarily focused on litigation against the federal government and against state governmental entities. And that's essentially mostly what I do today. And what I find the most interesting about the practice of law is representing individuals and entities in the clash with the federal government and in the clash with state governments, because at the end of the day, my view of our Constitution is that it's meant to protect the rights of individuals against the right of the government. It's not meant to empower government, it's meant to constrain government. And in a lot of these cases, what you're doing is representing individuals and entities where the government has gotten out of its lane and is not acting in the constrained fashion that our Constitution sets up.
So I have, followed your career as an illustrious appellate lawyer all of this time, but I'm, not as familiar with sort of that side of what you were doing. Can you give us an example of what somebody does in a government relations practice like that?
Sure. So it was just to be clear, it's the government regulation practice at Jones Day, and the government regulation group is much broader than what I was doing. It includes, our food and drug regulatory lawyers, healthcare regulatory lawyers, international trade regulatory lawyers. The component in which I practiced was what I would call government litigation. And it essentially, we were essentially representing people who had conflicts or companies that had conflicts with the government, or either at the federal level or the state level. So the first big case I handled in the Supreme Court was a case called the National Labor Relations Board against the Noel Canning Company. Mm-hmm. And that was a case that involved President Obama's recess appointments power. President Obama had made 3 recess appointments to the National Labor Relations Board, but he did it at a time where the Senate wasn't actually taking recesses because they were going into what were called pro forma sessions. That's where the Senate would meet every day for about 2 minutes, the sole purpose of which was to prevent the president from making recess appointments. And so the whole question was, could the president make recess appointments notwithstanding these so-called pro forma sessions? So it sounds technical at the front end, but at the back end, what it really is about is the authority of the government to regulate private entities through the National Labor Relations Board. And the whole idea of the appointments process is that before individuals are empowered to exercise that kind of control over the private sector, they have to be nominated by the president and confirmed by the Senate. And this recess appointments clause is a very narrow exception to the ordinary course where you have to have consensus amongst the branches before somebody is given that kind of regulatory authority. So while at the front end, it was quite technical, it really did feed into my own view of the constraints that the Constitution places on the power of the government.
Did you have a favorite case in private practice? Everybody's
yes. My favorite case in private practice it wasn't a case that went to the Supreme Court. It was a case that I argued in the DC Circuit. Many of you may have traveled to Europe and seen on their cigarette packages the gruesome graphic cigarette warnings that have pictures of people, smoking a cigarette through a hole in their throat and other difficult images. Well, the Food and Drug Administration some years ago proposed a rule that would have required that on cigarette packages in the United States. Jones Day, one of their biggest clients is R.J. Reynolds Tobacco Company. And so on behalf of R.J. Reynolds Tobacco Company, Lorillard Tobacco Company, Floyd Abrams, the famous First Amendment scholar, was my co-counsel in this case because he represented Lorillard Tobacco Company. We brought a First Amendment.
I represent
That's exactly right. That's right. We brought a First Amendment challenge to that. Won it in the district court, won it in the DC Circuit, and the United States did not seek Supreme Court review of it. So to this day, at least up until now, you don't have that kind of rule requiring graphic images on cigarette packs. And the reason I found it so interesting has nothing to do with, I have no love of cigarettes or anything like that. It's that it was an area of law that was essentially new. There were free speech cases. There were compelled speech cases. There were very few cases about whether the government could compel commercial speech in the context of warnings. And so we were essentially writing on a clean slate. And it made it fascinating and interesting to prepare for argument because you weren't standing around memorizing the facts of the holdings of cases. They really didn't get you anywhere. You were arguing from first principles and what ought the rule be under basic notions of free speech.
I teach that case in civil liberties some years and talk about, the extent to which the government's interests in compelled disclosure really do or don't extend to doing the equivalent of what the cigarette companies are accused of doing, right? Essentially, lifestyle advertising, right? If the government is trying to not get you to disclose factual information, but rather to convince your own customers that they shouldn't be your customers.
Yes.
It's that the first.
And I still remember my favorite part, my favorite moment in that case was when the FDA proposed the rule. They put out essentially a 500-page preamble to the rule explaining the basis of the rule. And I'm reading through all 500 pages, and literally when I get to page 499, the second to last page of the report, they bury a cost-benefit analysis. And there is a sentence in the cost-benefit analysis that says, and I'm almost quoting because I remember it so vividly, we estimate that the net benefit of this rule is not statistically distinguishable from zero. So we're like, okay, so you're making us do all of this for what you agree is no benefit.
Well, they put it on page 499 because they figured nobody would ever. Right. That's great.
They didn't realize that we were getting paid a lot of money to read every one of those 500 pages.
So another place where I ran across you in private practice was a day where we both had an argument at the Fourth Circuit, and mine was a boring antitrust case. But I ran into you in the halls, and you were there to argue Governor McDonnell's criminal appeal.
Yes.
Which I listened to and thought was one of the best arguments I had ever seen. How did you meet Governor McDonnell, and how did that happen?
Sure. So we were not initially representing Governor McDonnell when the case first started, but a couple of my partners were actually classmates of his from Notre Dame. And so once he got into trouble, some of my colleagues reached out to him and offered our services. And so he basically retained Jones Day to defend him at trial. And I was part of the trial team that focused on, legal issues, jury instructions and whatnot. But I wasn't putting on witnesses or giving closing arguments to the jury or anything like that. Once he was convicted and our focus shifted to the appeal, that's when I kind of took the lead front and center to handle the appeal, both in the Fourth Circuit and then ultimately to the Supreme Court, where we were fortunate enough to secure a 9-0 reversal of his conviction.
For the benefit of those students who may not remember, can you give them 10 or 15 seconds about what?
Sure. So Governor McDonnell was accused of taking essentially loans and fancy gifts from a man who was trying to get business from the state of Virginia for his pharmaceutical company, or it's essentially a vitamins company. What Governor McDonnell essentially did was asked staff members to meet with this guy. But his staff members all testified that Governor McDonnell never actually told them to do anything other than hold the meeting. And in fact, on direct examination from the government, they were specifically asked, what did you think the governor wanted you to do? And they would say things to the effect of, meet with him.
Meeting.
Want us to meet with him.
Right.
And so the real question throughout the litigation that we ultimately prevailed on in the Supreme Court was, if all you're doing is asking for somebody to meet, is seeking access, seeking a meeting, is granting access or granting a meeting, quote unquote, official action that the bribery laws prohibit? Because if it is, you're opening the door to a lot of bribery prosecutions. Since your typical campaign contributor, particularly the large ones, believes that they're going to have access to a politician if they give large campaign contributions. And I think there are a lot of politicians that are perfectly happy to create that perception that if you give me large donations, you're going to have my ear. It's not that I'm ever going to make a decision in your favor. I may or may not, depending on the merits, but at least you're going to be able, if you call, I'm going to pick up the phone. And so our basic argument was, if you understand the bribery laws to be that broad, you really are opening the door to essentially criminalizing at the federal level what has previously been understood to be routine political interaction between elected officials and their constituents and donors.
I remember in the Obley North prosecution, Judge Silverman wrote an opinion that basically said, if you interpret the congressional obstruction statute this way, then you might as well convert all of Washington's office buildings into prisons.
Yeah.
So I had a case that felt related to me for Arthur Anderson in the wake of Enron, where Maureen Mahoney and I represented them in the Supreme Court, and similarly, got a 9-0 reversal to Anderson's conviction. This seems to be a pattern to me, anyway, that you have these very aggressive prosecutions in the sense of pushing the boundaries of what is and isn't arguably criminal, that invariably seem to be upheld by the district courts and the courts of appeals, and then get to the Supreme Court and hit a buzzsaw, right? Whether it's Governor McDonnell, Arthur Anderson, Conrad Black, Bridgegate, you can rattle them off. But why do you have a theory of why that is?
So sort of. And I think Arthur Anderson is a particularly tragic case because you drove a major American corporation out of business on a theory that the Supreme Court ultimately reversed 9-0. So I think that's a particularly egregious example of this. But what you essentially have is you have prosecutors, federal prosecutors that are pushing the envelope. And as you note, not just the federal district court judges, but the lower courts of appeals approving that. And you kind of have this cycle that it then emboldens the prosecutors to go further. And then the lower court judges approve it yet again, to the point where I actually thought that Governor McDonald's case was the logical conclusion of this dance between the prosecutors and the lower courts. And throughout this whole dance, you have the Supreme Court in a series of decisions. You can probably count 10 decisions over the last 15 years where the Supreme Court 9-0 reversed the federal convictions on this basic notion of an overly aggressive interpretation of federal criminal law. So essentially you have the federal courts and the federal prosecutors that are, I don't want to say in cahoots, but they're reinforcing each other's views, and nobody is taking the hint from the Supreme Court, which over and over and over again is reversing by lopsided margins in this area. I know it's an issue that has been addressed by Solicitor General's offices across administrations. My predecessor, Don Verrilli, was very concerned about this trend. I was very concerned about this trend, and we both made it a point of talking about this with the U.S. attorneys to try to rein it in. And I think we probably both had some success, but you only have so much visibility into what is happening in 90 plus U.S. attorneys' offices across the country when they're making their charging decisions. But I do think that the U.S. attorneys' offices are starting to understand the risks, not only to their own cases, but to the Department of Justice as a whole, when they keep pushing theories that get such a cold reception up at the Supreme Court.
Justice Scalia's solution to this problem was the rule of lenity, but the rule of lenity seems to have fallen on disreputable times.
Well, I don't think so. I think if you look at a lot of these 9-0 reversals, the rule of lenity is part of them. Often it's explicitly referenced, but I think it's also often lurking in the background. The way I used to explain it to the U.S. attorney's offices when I would talk to them is if it's not clearly prohibited by the statute, then it's not prohibited by the statute. This is criminal law. You only put people in jail if we have, as a society, clearly said what you're doing is wrong. If we made it fuzzy, then we should clarify the law, but it's got to be clear.
I love it. So for the benefit of people on the Zoom who may not be as familiar with how all this works as you and I, what is the Solicitor General's office and what does it do?
Sure. So the Solicitor General's office, the thing that people think of is it's the entity within the Department of Justice that represents the United States in almost all cases before the United States Supreme Court. what I learned quite quickly is that it plays at least can play a much broader role within the executive branch. The Department of Justice it's the leadership of the Department of Justice basically consists of 4 officials: the Attorney General, the Deputy Attorney General, the Associate Attorney General, and the Solicitor General. Within those 4 individuals, it's only the Solicitor General that actually shows up in court and actually litigates cases. And so that informs the role that the Solicitor General plays as part of the leadership. Basically, the department looks to the Solicitor General to provide advice on how to pursue the major pieces of litigation, either pursue or defend the major pieces of litigation being carried on behalf of the federal government. So you really do work that goes well beyond the Supreme Court, and you advise on a whole range of important cases that are being litigated on behalf of or against the federal government. So you sort of, in a way, you're the lead litigator.
So one of the most disconcerting and amazing things about getting older is that these people that you knew when you were young and go on to do these just absolutely unimaginable things. For the benefit of a whole bunch of young lawyers just starting out, I mean, how does one become Solicitor General of the United States?
You know, that's a good question, and I don't think I have a very clear answer. I can tell you how I became Solicitor General. The best thing I did was when I was the head of the government regulation practice at Jones Day. I recruited a small group of lawyers from Patton Boggs over to the firm who happened to practice in election law, in the election law area. One of the people that we recruited happened to be a guy named Don McGann, who ended up being the White House counsel. So I don't know that that's necessarily replicable advice, but what I found is a lot of you develop your practice in a way that puts you in the running for jobs like this, and that's the most that you can do. And then there's a lot of dumb luck that's involved. There are plenty of people who are as qualified or more qualified than I was to be Solicitor General, and the cards just kind of have to fall the right way in order for you to get these kinds of jobs.
I remember reading the newspapers eagerly at the time, and there was a lot of buzz about, you know, Mike Carvin and Chuck Cooper, who were obvious candidates and would have been great. But also George Conway at the time seemed to be very much in the running. What would that have been like?
So it was interesting. I was initially the principal deputy solicitor general, and I would have had that job regardless of who was ultimately selected to be solicitor general. So I had many conversations with George, and I don't know if you've ever met George, but we sort of look alike because we're both half Filipino, half Western European. I think he's half Irish, half Filipino. I'm half Italian, half Filipino. So I would always joke with him that he was essentially a less good-looking version of me, and the justices would then start to get us confused when we were standing up at the podium. So no, George is a nice guy. I mean, you know, people know his views on things very well, but I've always liked George.
So a lot of other parts of the executive branch over the last 4 years seem to have a lot of trouble sort of institutionally dealing with the unconventionalities of President Trump's approach to policymaking. And, you know, there was a lot more leadership turnover than, you know, people maybe wanted or expected. But my sense is that the Solicitor General's office operated, you know, more or less as normal, including with, you know, the same Senate confirmed leadership for most of the administration. To the extent that you feel comfortable talking about it, can you tell us a little bit about why that was and
Sure.
What the relationship with the White House was like?
Well, I think the reason it was like that is because there's a difference between being a government lawyer and a government policymaker. And I think most government lawyers up and down the chain understand that. We have elections to decide who the policymakers are going to be and what policies they're going to pursue. And, you know, many of President Trump's policies were, you know, somewhat unconventional. But when it comes to the role of a government lawyer, our job isn't to redo an election, regardless of whether we like the outcome. The role of a government lawyer is to say, can these policy positions, whatever they are, be reasonably defended? Are there reasonable arguments that you can make in defense of the policy? Much like there are lots of statutes that Congress passed that I didn't like, but I was charged with defending because there were reasonable arguments that could be made in their defense. You apply at least as generous a standard when it comes to the president's policies and ask, can a reasonable argument be made in their defense? And that's not just my view as Solicitor General, that's essentially the ethic of government lawyers up and down the chain. And that's why I think by and large, you had the government lawyers, including longstanding career government lawyers who might not have liked every policy that we were defending, but were comfortable with the arguments we were making in their defense because they were reasonable arguments, and that was our role. Courts can best decide issues when you have good advocacy on either side, good ethical advocacy that's raising the best arguments in defense of and against a policy.
So one of our students asks in the chat whether there was anything during your tenure or since that you wouldn't defend that you could talk about, or how you decided sort of where to draw that line.
So let me answer it this way. I've had over the course of my career clients who wanted you to do things that you really probably couldn't do. But the key to being an effective lawyer, whether it's in the government or in private practice, is to understand what your client's legitimate objectives are. And often, you're not telling a client, no, I'm not going to do this. You're saying, look, I understand what your legitimate objectives are. Here's the way to get there in the best way that has the highest chance of success. That's the type of advice I give in private practice. That's the type of advice I give in the government, because frankly, you're often dealing with clients who aren't lawyers. They don't know what is a reasonable or an unreasonable argument. If they trust you, and once you explain it to them, most clients don't want to make unreasonable arguments because they know they're going to lose. So if you give them advice properly and you understand their objectives, you can get them to a place where, as a lawyer, you're comfortable advancing the arguments that need to be advanced on their behalf.
Did you have a favorite or most interesting cases, SG?
No is the short answer, mainly because the cases are so I have to say, I loved being SG. I don't like being in the middle of controversy all of the time. And cases that I might have found fascinating if I were sitting on the sidelines aren't particularly fascinating when you got to stand up there and get hammered for 30 minutes by the justices with every Washington Supreme Court reporter hanging on your every word. So I liked the job, fascinating issues. The cases tend to meld together in my mind. The part of it that I really liked wasn't the arguments, it was the strategizing. And the thing that I'm most proud about during our tenure is the strategy that we developed to, we were confronting, particularly early on, a judiciary, parts of which were, at least in our view, somewhat hostile to the administration and administration policies. And so we were losing very early in district courts, getting hit with nationwide injunctions that in just really hours after a policy was announced would essentially stop it dead in its tracks across the country. So very early on, we started to develop a policy that allowed us to try to get emergency relief up the chain, including to the Supreme Court if necessary, while other courts had a chance to address the issue and while it had a chance to be litigated up the chain in that case as well. That type of strategizing where you're trying to figure out how do we achieve the client's objectives is what I like best about the job. And I'm particularly proud that we were able to be so successful across the 3+ years that I was there in pursuing that strategy.
Yeah, I wanted to ask you about that. I mean, I sort of had the sense very early in your tenure that you were pretty aggressive in asking the Supreme Court to do things that the Supreme Court doesn't normally do, right? They have the power to intervene and grant stays in lower court litigation, at an early stage. they have the power to grant cert before judgment. And these are powers that they almost never use, and but that you were inviting them to be.
Yeah.
To be
So I'd say two things in response to that. One, the Supreme Court is, I think, more willing to do that than people understand, wholly apart from the stuff from the Trump administration. When I was representing Governor McDonnell, we actually got an emergency motion granted from the Supreme Court that allowed him to stay out of jail during the pendency of his appeal. The district court had essentially revoked bail. The Fourth Circuit has essentially agreed with the district court. So we had no choice but to go to the Supreme Court. And they essentially said, you know, there were technicalities to the argument, but they allowed him to stay out of prison during the pendency of all of the appeals. And so Governor McDonnell never spent a day in prison throughout all of that. When I was representing the Catholic diocese in the Little Sisters of the Poor case, the Supreme Court on multiple times granted emergency relief to prevent the religious organizations from having to apply with the contraception regulations during the pendency of appellate review. So I think that the court is more willing than some people think to entertain that kind of relief. When you put it in the context of my work as Solicitor General, you were absolutely right that we sought that relief more often than others, and a lot more often than others. And initially, I wasn't sure how much success that we were going to have. But two things: one, we didn't really have a choice. You had this massive explosion in the idea of nationwide injunctions, just a massive explosion in it. And it was to the point where you were going to have an administration that couldn't do anything, because you could also always find one judge out of the 500 district court judges in the country that was willing to grant a nationwide injunction. And that's all the plaintiffs had to do. We had to win every single case. They had to find one judge. And two, I think that their decisions were, some of them were sufficiently overly broad that the Supreme Court understood why we had no choice but to seek such emergency relief. So we initially were a little bit more cautious about it. We do this case, not that case. And then I think we started to get a feel for what are the types of cases where we're more likely to get relief. And we started pushing the envelope in those cases. What people don't see are all the cases where we didn't seek this kind of relief because we didn't think that it was something the Supreme Court would do. So I think one of the reasons we were so successful is that we knew how to pick our battles.
Fair enough. What do you think about, having worked a long career in both private practice and government service? What do you think about the relative advantages and disadvantages both for a lawyer and any advice for people just starting out about how to think about a legal career in the long term?
Sure. I think that one of the big advantages, particularly for younger lawyers working in the government, is you get a lot of experience at a very young age. We had outstanding young lawyers in the Department of Justice, career lawyers in the civil division, civil appellate, the antitrust division, who were doing trials, first chair arguments in the courts of appeals that far surpassed what some of their colleagues were doing in private practice. So I think that that's a good opportunity. On the other hand, I tend to think that when you're in private practice, you have an opportunity to see a broader range of issues. You have an opportunity to give, I think, more detailed and useful advice to clients. Often in the government, your position is kind of locked in, your strategy is kind of locked in. There's almost a cookie cutter pattern to how you defend a case. When you're on the private side, you often have to be a lot more creative in thinking about how to achieve your objectives, whether it's litigation against the government or litigation against private parties. So I think it's a good thing to think about spending a portion of your career in the government if you have an opportunity to. My own preference is for private practice. I really do enjoy representing clients in the private practice of law.
Unsurprisingly, we have a bunch of questions about the recent ideological shift in the Supreme Court and what it might mean for the future. I mean, you and I are of the generation that sort of grew up with the Rehnquist court that was unchanged for, it seemed like a geologic era. And now all of a sudden we have this court that's just sort of completely different. Mm-hmm. So we have sort of two different questions. And, one maybe is, do you see an ideological successor to Justice Scalia on this court? And, if so, who is it?
I don't see a particular ideological successor to Justice Scalia. I see that his ideas have essentially convinced a large number of justices and judges and others on a number of issues. I think when it comes to textualism, you see both Kagan and Gorsuch that seem to be carrying on Justice Scalia's textualist mantle, although I think he was a better textualist than either of them are. Although they're good, but I think he was better at understanding both the texts and the nuances of text. From originalism when it comes to the Constitution, I think Gorsuch is his natural successor, and perhaps Justice Barrett. We haven't yet had a chance to see enough of her. I think that Kavanaugh, Roberts, Alito are more in the mold of a Rehnquist. They are more in the mold of, they are conservative jurists, but kind of a common law-like development of constitutional law. Thomas obviously is a
so yes, no, or pass. Yeah.
On what?
Is the jurisprudence going to significantly change on employment division versus Smith?
I don't know. Is the jurisprudence going to change?
Right. Is the case going to?
I am skeptical that they're going to overrule it. I do think that there's a very good chance you're going to see them recognizing more exceptions to it, more instances where a law isn't neutral on its face and therefore is subject to strict scrutiny, notwithstanding employment division versus Smith. Because that's often where the fight is in those cases. It's often, well, this law isn't actually neutral on its face because it's got all these exceptions to it. And if it's got all these exceptions to it, you don't apply Smith in the first instance, you apply strict scrutiny. I think you may see an expansion of those types of exceptions.
Substantive due process.
I mean, substantive due process is so broad. I mean, you need to pick a particular area.
All right. What about the abortion case?
You had that great case, Scott, where the substantive due process right to get life-saving drugs if you were dying, and I think courts were reluctant to find a substantive due process right there, but that doesn't mean they're going to overturn all of the substantive due process jurisprudence.
President Trump signed the Right to Try Act that codified what we were seeking into legislation.
Kudos to you. That was a great, seriously, that was a great victory that you all achieved there.
Affirmative action, where's it headed?
I think that this court is going to be much less open to affirmative action type programs.
Yeah, I think it's hard.
Are they going to overturn it, or are they just going to narrow it? That's harder to say, but Roberts has long been on the more conservative side of affirmative action issues, and it's hard to see the newer justices being to the left of him on that issue.
Is there still going to be a commercial speech doctrine 5 years from now?
I don't know. I'm always a little skeptical that they're going to overturn major doctrines as opposed to take the tests and get them a lot closer to where they think it ought to be. I think that you've seen a long trend of giving a lot more protection to commercial speech, even if you haven't formally changed the doctrine. I certainly think that trend is going to continue.
How did you, it's an interesting question. How did you decide which cases you were going to argue as SG? Were there ever any that you didn't want to argue?
So in theory, the SG can argue any case he or she wants to argue. You have complete freedom of choice. In practice, you have virtually no choice because the Solicitor General has to argue the cases that are the most important to the administration or the most important cases generally. And typically in any sitting, it's pretty obvious what those cases were. So take the president's executive order restricting travel from certain countries. I couldn't exactly take a pass on that case and hand it to one of my assistants to argue. You pretty much, the Solicitor General has to argue that case. And for most sittings, there's a case like that.
I think I read somewhere that Justice Sotomayor asked you 62 questions in that. Is that,
I doubt that's the case because her approach is not typically to pepper you with questions. Rather, she'll engage in a fairly long statement of raising various issues within the case and then culminate it with one or two questions. So I doubt there were actually 62 questions that were asked.
So we interviewed now Justice Barrett when we were law clerks way back.
Is that right? I don't remember that.
He was with Justice Scalia the year after us.
Okay.
So one of the students asks if you have any thoughts about what kind of a justice she's going to become.
Well, look, it's hard to say exactly jurisprudentially where she's going to land, although I'm pretty confident she's going to align with the more conservative side of the court. But I am confident in saying that she is going to be a voice of reason and civility on that court. And I think that one of the things that was important to me as SG and that I think is important to the legal profession generally is that I think we have an obligation to model civil discussion for the rest of society, where I think a lot of discussion, the civility is broke down. I think that Justice Barrett is going to be a very good model for civil discourse for younger lawyers and others throughout the country, frankly, much as Justice Ginsburg was as well.
So do you have any, we're running short on time, I think it's after 6, but do you have a big group of young lawyers who are headed out to law firms like yours and to clerkships shortly? Do you have any advice about what to do over the next few years?
Yeah, I think that the most important thing for every lawyer to do is to understand who their client is and how to serve that client. When you're a young lawyer, your clients really are the more senior lawyers that you're working for. And your job is to make them look good. And to the extent you can do that, you're going to then move up to the next level where your clients are going to be, the companies and individuals who your law firms are retaining. And I think that it's sometimes frustrating to jump through those hoops, but the most successful lawyers that I know, at least in private practice, are the ones that did understand the different roles that you play at different stages of your career and just did the best that they could within that role, jumped to the next level, and then did it again as you move your way up the chain. So be patient.
You've had about as high-powered a career as it's possible to have. What has the balance been like? Have you been working miserably hard for the last 20 years, or?
I work hard. I'm just like you worked hard, and just like all successful lawyers work hard. But I don't think it's been unmanageable. I go to my children's sporting events. My younger daughter, I've convinced to take up golf, so the two of us go golfing once or twice a week. You can do it. On the one hand, you need to understand that clients are paying us enormous amounts of money to handle their matters, and so their calls need to be returned. But on the other hand, I think clients also recognize that we have to have lives as well outside of work.
So here's a great question to close on. Have you ever been asked to fill in for Peter Coyote as a narrator for the Ken Burns films?
No, and I don't even know what that is. I don't know who Peter Coyote is.
You're not a PBS aficionado, right?
No,
you probably watch you don't watch Ken Burns. Awesome. So what's next? You're going to run the DC office of Jones Day going forward. What's that going to be like? Do you know?
Yeah, I'm still learning the ropes in terms of that. It's a great new opportunity. I was at Jones Day before. I'm delighted to be back. It's a great law firm, a great group of colleagues in New York and DC and throughout the world. One of the things I like best about it is that you do have this global platform that allows you not just to handle matters for clients across the world, but get to know your partners across the world. And when you're in a position like the head of the Washington office, you really do get a chance to interact with lawyers in all of the other offices. And so back when I was at Jones Day previously in government regulation, I had a chance to get to know them too. And so the upside is when I travel around the world, it's always easy to find somebody to go out and have a drink and a cigar with in the evening, no matter where you are, just because you've done the same thing with them at the partners meeting in Orlando. So.
I thought so too, and I missed that more than anything else. Where did you smoke your cigars when you were Solicitor General?
So there is you're not allowed to smoke in the building. What I also learned is you're not allowed to smoke in the envelope of the building, and that includes at the Department of Justice. There's a massive internal courtyard. You're not allowed to smoke in the internal courtyard. And as Solicitor General, I had 2 balconies in my office. You're also not allowed to smoke off the balconies because they are considered part of the envelope in the building. So as a result, I would go out, Scott, you may remember on the corner of Pennsylvania and 10th Street, there's a park bench that sits on the corner outside of the department. I would often go out there with a pile of briefs and sit on that park bench and smoke cigars while I was reading and editing briefs. And one of my favorite stories about that is occasionally when it would get really hot in the summertime, I'd walk a block down to in front of the Trump Hotel where there was a tree, and I could sit on a park bench in the shade of a tree. And I was having a cigar, and I got up to go into the hotel to use the restroom. And so I set my cigar down on one of the ashtrays that was there on the sidewalk. And when I came back, one of the homeless gentlemen who was in the area was sitting on my bench, smoking my cigar. And he looked at me with a big smile on his face. And I just told him to enjoy it, sat down and lit up another one.
I know this because I have a friend at Civil Appellate who used to be able to see you out of her window, sitting there transacting the business of the United States from the cigar. Awesome. Well, I know we promised to let you go as close to 6 as we could, and we're already over. Thank you so much.
Thanks, Scott. My pleasure.
For this, it's great to see you. Give my best.
Likewise. Good luck, everybody. Okay. Thanks.
I hope we can get you to Charlottesville.
I would love that. Okay. Bye. Awesome.